other options for you today. So what we thought we would do is just briefly introduce ourselves. My name is Bernadette Feely. I'm from Suffolk Law School in Boston, and I run the general externship program at Suffolk. So in my class, I have students doing everything from A to Z. So I have students doing judicial externships, in-house, corporate, private firms, government agencies, everybody in the same seminar. And we'll all just quickly introduce ourselves, and then I'm going to begin today's program with about 15 minutes just talking about possibly incorporating an email etiquette exercise into your externship class.
Hi everybody, my name is Colleen Scarola and I am at Denver Law as a visiting assistant professor of the practice, long title. And I currently supervise private sector placements, corporate externships, and then judicial. Our structure, as I'll talk about, is a little different to where we design topics, so it's not really generalized, it's more specific topic seminars. But I have had students in the public sector outside of judicial in my seminar classes.
I'm Jennifer Rovig, and I actually do not have that much to do with extern programs. Sarah Shell, my colleague here at Emory, is the director of our externship program and my friend. And I'm also friends with Kendall Carew, who helped me from Georgia State, who helped me get on this panel because I teach regular classic legal writing, and then I have an advanced legal writing class in blogging and social media, where students, their final project is to create a capstone WordPress blog on a topic of their choosing. And I think that there's a lot of opportunity for that kind of writing. My understanding is lots of opportunity for public writing in extern programs, and also just write different ways beyond, a memo. There's more things to life than a memo or a brief, and so that's kind of my connection to the panel.
Great. All right. So I'm going to begin by talking about possibly adding an email etiquette exercise to your externship component. So, you might have many different goals in doing this. I think the first two that I've listed are pretty obvious. Talking to students about using a professional tone in email communication or effectiveness in email communication, but there might be other goals as well. Like, for example, you could use that exercise to talk about seeking appropriate guidance on projects or writing and self-editing, or you might have other goals. So I think what your goals are and where you want, I think it depends kind of on where you want to insert it into your classroom component. So just some suggestions of where you might possibly use an email etiquette exercise in your externship component. The first one is, it's not listed there, it's just, in and of itself. You might just decide that you want to do a 15-minute exercise with students just talking about email etiquette. I know for me, I have a 2-hour seminar. Sometimes I plan something and it lasts like an hour and 35 minutes, and I always bring in some extra things to talk about in case we finish up a little early. So you could use it that way. The one thing I will tell you is that I taught legal writing for many years, and we did not do an email etiquette or an email exercise component in our class, but several, I think many, or a fair number of programs around the country have added that into their legal writing program. So I've talked to the wonderful people that I work with in legal writing, and they are using it. They actually started it a few years ago, and I will tell you, because I've been at the school for many years, it was like night and day, the difference in when they started to insert that into their class and the types of emails I was seeing before and after from students. So they thought it would be great to kind of use this to reinforce it in the externship class, because of course our students do a lot of emailing with their field supervisors and others. So, so you certainly could use it in and of itself. I have been using it in that very first class where I'm talking about the relationship between field supervisors and externs, how to get good guidance on projects, professionalism, you want to be professional, presenting yourself. That very first class, I've been kind of using it as a sort of at the end of that class. You could also possibly use it if If you, in Learning from Practice, Chapter 9 on professionalism for lawyers, you could put it into that class. Confidentiality perhaps, I think Chapter 11 in Learning from Practice, there's a section on confidentiality with technology. You might work it into that class. If you do something on legal writing and self-editing in your externship class, you could use it there as a sort of a short exercise to do. So there's a lot of different possibilities of where you might insert it. So I think everyone should have a 3-page handout that we sent around. It's actually, they're stapled together, but they're 3 separate handouts. I just stapled it for the convenience. So the handout is, the first page is some sample emails. The second page is sort of 10 ways, 10 points that you could make with students in a class that you're using these emails as samples. And then the last page is a list of resources that I think are helpful for you if you're deciding to add this, or even just to give to the students, if we're talking about professional emailing. So if you look at that first page, so I have 2 sample emails. And this was the scenario that I gave my students, that the student was at his externship on Thursday. The field supervisor gave him an exercise, gave him a project, a research project, and then the field supervisor was going away to visit relatives to New York for the weekend and wouldn't be back in the office until Wednesday. So the student realizes that he has some questions and he emails the supervisor. So my goals in writing this first email, you certainly could use my sample, but I assume you might want to create your own sample. But my goals for this first one was to demonstrate someone who's using a very informal tone, is not careful about grammar and editing, misspelling and that type of thing. The tone is not overly courteous. I wouldn't say it's overly abrasive. I tried to make it believable. And someone who comes across as someone who likes a good time. So, hi. Oh, so again, hi. I know it's Sunday, so I'll keep it short. 2 questions. Do you want me to write up the research I find on the motion filed by defense counsel? Do you want a memo on it, or do you just want cases? And when do you want it by? I also want to talk to you about spring break. I was wondering if it's okay with you if I go to Florida with my friends for a week. Italics, exclamation point. Since I work Tuesdays and Thursdays, I'll only be out 2 days, Paul. So I've rewritten it to the second one. My attempt was to demonstrate someone who is using a respectful tone, is courteous, not stuffy, but very courteous. Someone who's appreciative of their field supervisor's time and guidance, someone who comes across as taking their work seriously. So if you look at the second page, I just, pulled out like 10 points that you could make in class with something as simple as that, 3 or 4 sentence email that, and so, I put the email up and everyone has a copy and we talk about some points. So the first one, the subject line, always included, I tell them, be as specific as you can to help the reader. Not only, maybe she sees, William's sanctions memo and realizes, I can wait until I get back to, it's a courtesy thing. Do I have to open this email now or not? And also if they're searching for it later. So saying something like the student says, see below or FYI is not that helpful. The salutation, hi or hey, I think perhaps we've all gotten those from our students. So, just discussing, include the person's name, dear Joan, hello Joan. I also use this as an opportunity just to talk about, maybe not necessarily with their field supervisor, but if you're emailing someone in a professional setting for the first time, to err on the side of formality, use the Mr. or Ms. if you're unsure. If they sign it, Maria, then you can maybe refer to them as Maria from there on, but err on formality at first. Begin with an introductory greeting. I think this student is attempting to recognize that they're infringing on the person's time by, it's Sunday, so I'll keep it short, but begin with a pleasant greeting, I hope all is well, I hope you're enjoying your weekend, that type of thing. Number 4, and as you see, I've sort of, I actually did it to the students this way, you didn't have to do that, but I've circled 1 to 10 on that sample email. But carefully edit that it's a professional email, it's not a casual text to your friends. So this is an opportunity to discuss self-editing and grammatical mistakes. I actually use it if you have some pet peeves or things that you see in your students writing a lot that you just want to point out, like how many times have I seen the word counsel misspelled? How many times have I seen it's, ITS, IPG apostrophe S? Hopefully it's laziness and they really know how to use it, but so whatever you want to bring out, grammatically, you could focus on that. Number 5, give the reader background on the topic. Don't assume that she remembers. So here he's looking for guidance. He dives right in. Do you want me to write up the research on the motion for defense counsel? Just recognizing that you're thinking about this. How many times have we all been stopped in the hallway by a student 3 weeks after they've come to see us? Oh, that man, I wrote to him. He's like, what are you talking about? So just, back up. Last Thursday you asked me to conduct research on the response to motion for sanctions in the Williams case, and then here's your question. So give them the courtesy of reminding them what you're talking about. Number 6, so here he's seeking guidance on a project. And here's where I use it. As I said, I use it in my first class when I'm talking about, it's your responsibility too to get good guidance on projects. So I actually, make a list about talking to the students about what is it that you need to know when you're given a project? What is it that you need to know, that you want to make sure before you get up and walk away with the assignment that you understand things like format? And I just make the list. So it's an opportunity to discuss that. So format, do they just want cases? Do they want an oral report? Are they expecting an objective memo? Are they looking for a draft for something that's going to be filed in court? What is it that they're going to be looking for? Understand the context. Talk about due dates. When are things due? When do you need it by? When's the final thing due? If you need samples or models of something, if you're being asked to answer interrogatories and you've never done it before, looking for some samples. Maybe talking about research strategy right there at the beginning, talking a little bit about how you might approach the research. Priorities, what if you've been given an assignment, on Monday, and then you've got this new assignment, which one, should you put that one away, which one is more important? So all of those things I use this as an opportunity to discuss that. Make sure that you have the guidance you need, at least as much as you can figure out you need before you go off, so that you don't then have to, email them on the weekend. Number 7, I use this to talk about what not to discuss in email. So here it is, February, he's talking about spring break. Do you really need to do this when she's away? And also, some conversations are better, perhaps he's already committed to work March break and really something has come up and he needs to discuss it. Does that have to, maybe it's easier to be done in an email, but the more professional thing to do, talk about it face to face. Is there sensitive information that shouldn't be put in an email? It's an opportunity to discuss, again, Chapter 11 in Learning from Practice, balancing technology with confidential information. What shouldn't you put in an email? Number 8, exclamation points, not that you can never do it, but it's not a text to a friend. Certainly tone it down, don't overdo it. And then just, again, reminding them, this is not a formal memo, but it's not a text, it's kind of somewhere in between. It's like a conversation, but normal voice inflection conversation is not here. Remember to say please, remember to thank them, that kind of thing. And then, the closing, a lot of people, think about what you want to use, best or best regards or sincerely or something like that. The resources that I've given you sort of expand on all of these points that I've made, and then they talk about other things as well. So, like one of them just talks about like the signature block at the end, and I didn't include it in here, but your signature block and what you should put, and thinking about, do you really want to put, go Pats at the end of that or something like that. I'm from Boston, I guess you know that. And then, when should you respond, within 24 hours, even if you don't have the answer to the question, respond to say, I don't know, but, I will get back to you at the end of the week with an answer, that type of thing. So I found the resources helpful, and it's helpful for the students, I think. And that's it.
Oh, sure. Sorry. Okay, so my portion of the presentation, I'm going to talk about the social media legal externship course I designed and that I teach at Denver Law. So I guess the first question is, why social media? Back in 2013, in response to the annual ABA technology survey, we saw an increased number of attorneys reporting that they're using social media in both their personal and professional lives. In fact, the results indicated that 80% of attorneys that responded to the survey are using social media professionally. And that number increased to 94% of attorneys that are maintaining an online presence when you look at it for personal reasons. Out of those attorneys that responded, those working in the private sector, 71% of their law firms employ social media, and their websites link to Twitter accounts, Facebook pages, and to individual attorney blogs. And out of those 71% of firms, 51% of the firms actually have their own law firm blog. So I think it's important because social media really permeates every layer of our culture, and specifically in the legal profession, it has fundamentally changed the way we communicate with each other, with our clients. Unfortunately, in some instances, not the best way to communicate with clients, which I'll touch on. With the courts, and what I'm seeing at Denver Law is that we're seeing an increased number of students that are being asked to employ social media at their placements, whether it's updating their organization's blog or doing case summaries on the blogs, doing Twitter feeds. So we've seen that number increase, and that's one of the reasons I think it's really important. When I stepped into my faculty role at Denver Law, there is no comparable course. So this course really fills that gap, and it allows us to talk about different critical issues that touch on so many different things. So really for the seminar, I have 3 goals. First is getting the students to understand why we're studying social media and why it's really important. I feel like a lot of the students, it's because they're millennials or post-millennials, social media is so embedded in what they're doing that they don't even realize it. I've had to ask students to put their cell phones away during class because they're constantly on their phones. And I know that's a different type of technology, but walking around the class, they got their Facebook pages up, their Twitter accounts. I can't get their minds to focus. So trying to get them to understand why it's important, why we're studying it is one of the goals. The second goal is to really recognize the various legal risks with social media, that it cuts across almost every single practice area, including litigation, employment issues, constitutional issues, dealing with privacy, and then last, but one of the most important that students seem to relate to is really identifying the ethical risks of using social media. As law students, as lawyers, and then also their clients, and how you navigate potentially murky ethical social issues which seem to continue to come up. And I apologize, I talk quickly, so feel free to cut me off. Some of the seminar topics, it really depends on what the makeup of the class is. So we have, like I said, at Denver Law, we design seminars that, really are based on different topics, while we'll have some that are, I guess, more general and will incorporate a variety of different things. We have very specialized seminar topics. So I've had students across all sectors take this seminar, and depending on who's in the class, it really influences the topics that I choose and how I discuss and teach those in the class. But some of the, I guess, common topics that we talk about is, one, as I mentioned, the legal risks of social media, so looking at different brand viral nightmares and what happens when you jump on a trending topic. I've had law students actually do that, and it's raised red flags with the dean in terms of certifying their bar application. Our dean takes a very, very, very proactive approach and won't just certify. He does his own research, and he looks at the students' social media, does Google searches, and so that's going to change from our former dean. So educating the students on that and knowing what they're putting out there doesn't just disappear because they delete it is one issue that has come up. Looking at the terms and conditions of social media platforms, which is related to students not understanding that maybe they put something out on Snapchat and thinks that it has disappeared. A story, I had a student that inadvertently sent a Snapchat to their supervisor. I don't know why they were following their supervisor on Snapchat, but it was a picture of the student in a bikini out at an event with some friends, and thought they were sending it to their friend Chris, not their supervisor Chris. And the supervisor, responded back and informed us, like, hey, I don't think you meant to send this to me. And the student had been drinking and, of course, was mortified. But so understanding, privacy settings and things of that nature. Privacy rights and policies. We look at different social media platforms, privacy policies, and there's always a lively debate over whether there is a right to privacy on the personal information you're putting out on social media, and whether that differs depending on the platform you're using. So Twitter as opposed to Facebook, and how their placements are using it. And then I'll get into more of a deep dive on discovery and evidentiary issues and ethics and professionalism, which relates to how do we counsel our clients on their social media use. So throughout these topics, I'm really encouraging the students, whether I'm telling them they're actively reflecting on it, to think about these things and to really think about how they're using social media both professionally and in their personal lives, and to also look at how their placements are using it. So, for instance, in the first class of the semester, well, prior to us meeting this, I'd have the students sit down with their supervisor or another attorney at their placement and ask them what is their organization using in terms of social media platforms, and what are those individual attorneys using. And then during the first class, I break the students up and they essentially take an inventory of what their placements are using, and it really does differ if they're at like a public defender's office or a DA office, and then if you have a student at a private law firm. And they look at that and we talk about how are these placements using social media? Is it the most effective way? Is it furthering their mission? Is it, for the private sector, are they trying to increase their brand? If they're at the corporation, are they trying to attract clients? And is it working? At the same time, we also talk about what those best practices are of using social media. And we kind of come up as a class with what we think the best practices are. And then following up on that, the students, I give them an assignment where I essentially make them do a social media check and go through an inventory how they're using social media, And some, surprisingly, some of the millennials don't use social media at all. They've either used it in the past or they, for some reason, don't even use LinkedIn. So if they don't have any sort of presence, I'd make them at least create, I should say make, but it is part of their assignment and participation, create a LinkedIn account, because as I'll talk about later, I really do think that you have to have some sort of social media presence to be successful in the legal profession. And I have them, while they're doing that social media check, look at what they've been putting out there. Some of them don't realize, pictures from college can still be seen on, Facebook when you go back and look, and there's pictures of them drinking and partying in Colorado with this issue come up with cannabis being legal, students partaking, and putting pictures up there of 420 innuendos and things like that. And so I have them do that. Another thing we talk about is, do their placements have social media policies? So some placements actively have, whether it's in their handbook or they have some standalone internal policy saying how employees, while they're at the placement, can use social media, and even rules that affect how they can use it outside if they're reflecting or discussing what goes on at their placement. Some organizations don't have a social media policy, so we talk about, should there be policies across the board, and what should those policies look like, and how would the students, if they had the opportunity at their placement to create a policy, what would that look like? Sorry, I gotta go back. Related to that, we also talk about branding, and that's something I feel, really strongly about, is using social media to brand yourself. And as Jennifer will talk about in a little bit, part of that is you can use, by creating blogs, you can really demonstrate that you have a substantive knowledge in a particular area of law, and that you are putting yourself out there, which can be helpful depending on what type of practice area or sector you're trying to get into. And in addition to that, we talk about ethical obligations, which I'll deep dive into, but do attorneys have an ethical obligation to vet their clients' social media? Do we have an obligation to groom our clients' social media presence? Should we be proactively doing that? And that really does spark a lively debate with the students. Some feel strongly for it, and some are against it, and some are somewhere in the middle. So one of the issues, and I picked two topics that across sectors and in the evaluations I've received, these have really resonated with students, and it seems to apply nicely no matter what sector you're in. The first one is looking at the discoverability of social media, and then also evidentiary issues. So we start that course, or that class, at really looking at the various approaches that judges take in resolving social media disputes, because it really is divided, even in Colorado and across the country. The first thank you. The first handout is, it comes from the ABA and a law firm, DL Piper, and their social media discovery requests. And so what I do is one of the in-class, simulations, I have the students, we work off of, a hypothetical fact pattern, and I have the students come up with templates or different types of discovery requests and deposition questions that they would ask related to trying to get social media based on that specific fact pattern. And then we also, either in that class or a different class depending on timing, we look at traditional rules of evidence and how you get social media admitted into evidence. This seems to happen more so, I would say, in criminal defense world with students at DA and PD offices, and then also in certain private sector practice areas, like personal injury and insurance defense. These issues seem to come up a lot. And during that section, I have one student act as the judge. I break the other students up into 2 small groups, and one student from each group argues for and against the admittance of social media evidence based on a fact pattern. So those exercises seem to really, the students like getting adversarial, for one, in a civil way, I should say, but it really helps them connect what they're doing at their placement. Sometimes they see discovery requests and it doesn't include social media, and they've been proactively, because of the seminar, including that, and supervisors have said, oh, that's a great idea, you know, how did you think of that, or why are you looking at that? So they've been able to take some of those practical things and apply it at their placement and essentially get kudos from their supervisor. Then another section where students, the topic seems to really resonate with students, is talking about ethics and professionalism. And we start out by looking at the Colorado character and fitness standards, and then also some states like New York where they specifically have spoken on social media. We'll look at that and use that as guidance to look at how students' use of social media can impact their bar application. And we have frank discussions about, I mean, they know now that the dean is looking at these things. They know that in Colorado, even though there's a formal ethics opinion about the use of social media, there hasn't actually been a case where a student or a graduate's been denied admittance, but the bar examiners have the option to look at social media. So we look at that and how it seems to be developing in Colorado, and looking at the states where it's a little more fleshed out. We look at the rules of professional conduct and apply that to social networking, how the students and how their placements are using that. And related to that, once they are practicing, looking at how they act, how they market and advertise themselves through things like blogging, and trying to gain client development if you're in the private sector, and how you apply those rules to make sure that you're still doing things with, you know, in their purview of ethics if you're utilizing social media for these things. As I mentioned, Colorado in 2015, they came down with an ethics opinion that addresses how you can use social media as an investigative tool. And so we look at that. I have the students read that opinion, and we apply it to things that they're doing at their placements. And there's been issues that have come up where students are like, I'm not really sure if I'm supposed to be, if I'm able to do this kind of research that they're asking me to look at and using social media for, and then just what in the parameters of what they're doing, how far can you go with being using it as an investigative tool and not crossing over into the murky issues. We talk about how you counsel clients on social media use. This has actually come up in placements where they're sitting with their supervising attorney or another attorney that's saying, hey, we looked at, you know, we vetted your social media, you need to take things down. You can't do. Or, you know, you need to now be, but what you can do is you can say, well, you need to be conscientious going forward. Don't put anything related to the accident or the crime on social media. So having students understand what you can and can't do in those situations. And then we spend a lot of time, because judges are in their own I don't know what a nice word to say, but they're in their own section on this, because there's rules for social media that apply only to judges. And we look at a series of cases. I bring it in and have the students, and we're going to use one of the HIBOs as an example, but give them these fact patterns based on real cases where judges have been reprimanded, sanctioned, or where there's been no sort of reprimand put on the judges based on the judge's use of social media. And I have the students decide, well, if this came up before you, how would you rule on this? Do you think there's an ethical issue? Would you reprimand the judge? And it's really interesting to see the students' different, I guess, gut reactions to that. And then I tell them what the actual result was. We look at friending, which you'll hear a lot about, like, can judges friend attorneys? And there's really a division across the US. You have some states that outright ban it. You have states like Colorado that have not spoken on it. You have states like California that adopt this hybrid approach where, yes, judges can be friends with attorneys as long as there's no active cases in front of them. And that really sparks a conversation with, I have the students talk to, you know, their supervisors and again, attorneys at their placements and see, do you follow any judges on social media? If so, what platforms are you using? Who are the judges you're following? And what routinely seems to come up is supervisors or attorneys that went to law school or had a colleague prior to that colleague going on the bench. And what do you do at that point? Because there's a foundational relationship outside of that attorney just appearing before them. And so how do you handle that? And so we're going to look at hypo number 3. I gave you, these are hypos I used throughout the seminar. Feel free to use them if you do anything on social media, but so I'll just read it quickly and then love to hear your thoughts. So Judge Tierney is in a dispute over child support with the father of her children. She sees a picture on her ex's Facebook page, still friends, of him with his new girlfriend. They're on a vacation in the Bahamas. Judge Tierney is very frustrated and angry and posts a comment on his page stating, quote, "It must be nice to take such an expensive trip but not pay your bills, just saying." Do you think and I asked the students, do you think there's any ethical issues here? So I'll pose that to you all. In reading that, do you think there's any ethical issues? No wrong answers.
I think it would be if she wasn't a judge. The judge part is tripping me up.
And ethics versus professionalism.
Yeah.
I don't know that there's a straight up ethics issue, but doesn't mean that she should be posting it.
Anything else?
Could she be trying to like influence the judge in the dispute case, like to basically add proof that whatever she's going to later argue is like the truth and sort of influence on her colleague on the bench or something?
I think that's actually an argument that came up. This is based on a real case that came out of Indiana, and the Indiana Supreme Court found that this conduct was not essentially becoming of a judge and banned the judge from ever serving again in the state of Indiana. Yeah, it's actually, if you look at, I know, if you look at the cases where judges have been reprimanded, that was one of the, I guess, harshest sanctions. But the judge was banned, and this is the exact quote. There was nothing else. It was this on the Facebook page, and they had screenshot that, and they, found that, a judge is held to a higher standard and can have the ability to influence the public and influence law, and so therefore they impose this sanction.
Was there any recognition of like whether any other judges could even see this post?
No, but that's a good point. It was what they found. What they also talked about is that putting it out there on social media, presumably anybody can see it, even though it has to be. You have to be friends with the person. They also they thought the conduct was deplorable for a judge to do that and make that a public statement on their ex's Facebook page.
Was there a range of comments that resulted in that same outcome?
By the students or by the?
No, that there was that recognition that this is deplorable as opposed to what?
Oh, I see what you're saying. In the ethics opinion that I read, they didn't talk about that, but I can say just from having several classes discuss it and looking at other cases where I think conduct that judges have done has been worse than this. To me, this is more of a harsher penalty than what some other judges have had still. But it could be also the state and the makeup of the courts, the Indiana Supreme Court at the time too.
Or it could be that she's a woman.
Yeah.
And that when you're complaining about child support, it's only okay. You know, I don't know, it's hard to,
It was a
based on
smaller
what you just
town
said.
in Indiana, so.
Well, I also think that, I mean, even our millennial students don't understand how social media works and who can see what, but I kind of wonder whether they were aware that, I mean, whether they even inquired whether this was public or whether it was only visible to like a few friends. And on the other hand, I had a student who sent out something on Twitter and said, well, so, you know, it was private, I only have 300 followers. So, you know, I mean, I think there's this sort of sense of like, I'm posting it, but it's either it's private or it's public, and not a recognition of sort of the audience.
Well, the ex-husband's page was definitely private, but they said by putting it out there, he made it public to all of his friends on Facebook.
Isn't there a rule that you don't have a reasonable expectation of privacy anyway because you don't know who's on the other side of the computer screen looking at it with them?
Exactly, and that's an argument too that comes up with the students often throughout the seminar is that, well, there is no expectation because you don't know if they're showing it to other people, and anybody could, you know, walk by your screen, or you know, presumably you're putting it out there, whereas other students say, no, I'm very intentional in who I friend or who I add as a Twitter follower, who I don't use Snapchat, but who is my Snapchat friend. And so therefore I do have a limited, you know, privacy right.
And I think it is different, actually, to your point, that it was a comment on somebody else's page rather than a post on their own page where they do know who all their friends are and know whether or not there are judges on the other end of that or whatever, yeah.
And I think it would have been interesting if if this judge posted it on her own page, you know, essentially venting about her ex-husband, if it would have been the same sanction and reprimand than if she posted it on her ex's page. So it's really interesting to see. And so some of the, you know, results that I have seen from teaching this seminar is, one, as I've mentioned, it's been really well received by the students. They find that a lot of the topics and the exercises that we're doing in class are really relatable to what they're doing in the placement, and then just also in their world as a law student.
Is that also true for the students who are working in the prosecutor's office and the public defender's office? That doesn't, branding and networking and those sorts of things don't seem really relevant to those jobs?
Yes, that's a great question. So yes, because when I have a mixed seminar, I don't focus as much on we discuss social media more in terms of the ethics, the discovery, how you use it as an investigative tool, and less on the, you know, branding and the client development. Although we do talk about it in the sense of how their organization can use it to further their mission. And so we are seeing some DA and public defender offices, at least in Colorado, that are, you know, they're not doing specific blogs on the cases, but they're doing blog, you know, victim advocacy, free seminars for the community, and they'll do a blog post on that, or, you know, update their website with, you know, different CLE events. So I try to be very conscientious of making sure that it really is applicable to all of the students in the
And I don't want to get too much in the weeds, but as far as the discovery issue for the prosecutors and the public defenders, I was in civil practice, I didn't do criminal. Like, you would never use anything like this in criminal practice, right? It's discovery requests.
Wait, I'm sorry.
Well, you can get a search warrant
Okay.
Yeah.
All right.
or an administrative subpoena, depending on your state.
Okay.
Also, law enforcement can get to things that other people cannot.
And I have, and I do, when we're talking about discovery, because I use it for both civil and criminal side, and I have examples of cases where defendants have put things out on social media. Like, for instance, I have a clip, which has now been taken down, but I was able to get it, when somebody essentially stole a bus and then videotaped themselves on this, like, $2 million like decked out bus and then put it on YouTube, and how the DA office was able to use that and got it admitted. So, you know, really, some of it is like, can you get it without a warrant, but also looking at when people put it out there, you know, freely, like a YouTube, that you can access it and use it to further your case.
But you also don't want to be the one to access it, because then you're making yourself a witness. You want to make sure the investigator or your detective does it as well. And then there was another ethical issue that I forgot, but yes. You don't want to be the one to become a witness, because then you can't handle the case.
Which the students bring up, and
I remember, we always tell them, do not friend. There have been issues with people trying to friend witnesses or defendants
Yes.
to try and get
No.
more
Yeah,
access.
no.
Which are, again, right,
Yeah.
definitely, but like, you would think everybody would know that, they do not.
there's
It's a good
actually
reminder.
some hypos on there based on real cases where attorneys instructed their paralegal or their law clerk to friend a witness or an opposing party, and can you do that? And what are the ramifications if you do?
Can you talk a little bit more about like what you tell them when it comes to branding and
Sure.
what kind of tips you give?
Yeah, so I really, one of the things I tell them is to really identify like a niche or a practice area or a career goal that they have, and number one, use social media to learn everything you can about it, because there's so much information. Second, I tell them to connect with social media, connect with influencers in that space using social media. And I think that's really important where maybe the geographic location they want to practice, there's not a lot of opportunities for that. So for example, I have a lot of students that say they want to do sports and entertainment law.
Yeah, everybody does.
Yeah, in Colorado, and while there's some opportunities, it's very limited to get into that right out of law school, or to even find placements for it. But I tell them, if you can connect with people and start building your network, it can open those opportunities that are not just going to fall into your lap, because it's not like going into DA or PD office or big law. There's not a straight career path. I also encourage them, and then after Jennifer's presentation, hopefully we'll be able to integrate more of this, but to think about ways to use social media to create their brand. So starting a blog where they're talking about the practice area that they're really interested in, and being able to demonstrate to employers, not only do they have a genuine interest in it and they've been proactive in developing that, but they have the substantive knowledge to do it. And I have found that really helpful in terms of, you know, helping them create their brand.
Do you have many that take you up on it and start blogs?
I have actually,
Good.
which has been great. I've had students that said they'll never use social media. But then I have a student that now won't do blogging, but does the micro-blogging, as I refer to Twitter, so that they're, you know, they want to get into civil rights work. And again, that's another practice area that's difficult if you want to just go into, you know, certain nonprofits or, you know, private firms that do it, and you don't want to go into like the public defender's office. So I've had one student that I'm thinking in particular that's created a Twitter, and everything is like micro-blogging about, you know, civil rights related issues. So only a 2L, so hopefully like another year of doing that and building contacts in that sphere will lead to, you know, an opportunity. I try to, that's one of my goals, is to really make it, you know, while you're reflecting on it, trying to figure out what you want to do, to make concrete steps so that you can get to that goal, so that you can be a happy lawyer and not a student in my office crying about how much you like hate where you are at your placement or where you kind of ended up. And then really briefly, these are just some of the resources that I found helpful, and I can send those around. In addition to those, I really routinely look at like the American Bar Association. They have a whole web page with different articles on social media, ranging everywhere from ethics and professional responsibility of social media to some of the logistics that Bernadette talked about of just using email etiquette, blogging etiquette, and I look at the Colorado Bar Association and then some other states that have put out really good sources on social media. And then, of course, any trending social media topics or things that come out. Last fall, one of the prestigious university had some issues with admitted students that they ended up retracting their acceptance based on their social media use, so we talked about that in class. And then I routinely have students, even past students, that will send me an email saying, hey, I saw this article or this discussion on social media, you should, bring it to class. So it's really evolving. Thank you.
So, I'll tell you a little bit about my class and then get into the slides on sort of what, I have a teaching idea that I think an externship director could use to help students become even more prepared to do public legal writing in your externships. So I was a journalism major in college, then went to law school, and I was a summer associate at a firm, and they asked me to write a magazine article about whether journalists can go through people's trash. The legality of just like going up to the trash and like going through it. And I'm like, this is in my wheelhouse, I've got this. And you know what, that was like one of my hardest assignments. I could not crack that and really, I knew I didn't do I did an okay job, basically. And it was disappointing because I felt like, this is exactly what I should be able to do. That was like 20-something years ago. And everything was fine, my summary judgment was fine, but my journalism article didn't go over so well. So that was kind of in the back of my mind when blogs and social media for lawyers started becoming more prevalent. I was busy starting a family when blogs got really took off in like 2002-ish, and so I didn't really get into it. But a few years ago, I wanted to start blogging. Legal writing is my field, and I'm like, well, I could write about legal writing every single day, but there's already a whole bunch of blogs about legal writing, so I'm like, I don't have anything special to add there. This goes to your point about starting a niche and finding something that is not being said. So some folks in legal writing, we had been talking about like, students maybe being we've been complaining really about students on their phone or like, I know I said this, how come they didn't do it? Like that kind of thing, and I realized in my class I was like grading memos and this one might be just as well written as this one. The writing itself is the same, but this one has what we talked about and this one doesn't, And so I'm like, the writing is the same, but the listening is actually much better in this one because they heard what we talked about and implemented it in their writing. So my blog that I started is called Listen Like a Lawyer. ListenLikeALawyer.com. And someone's like, you mean horribly and with preconceived notions? Yeah, basically. I guess it has a double meaning. So that's my blog. I've been doing that for 4 years, and that was part of the packet. That helped me get ready to start my class, which I co-teach with the IT director at the law school. We've taught it for 4 years. We usually have about between 15 to 18 people in the class. And it is a 3-part class where, as I mentioned before, they work towards their final project of picking a topic, picking a niche, and then designing a WordPress blog with about 7 or 8 posts on the blog and about page. They have to use photos. They have to design the theme to fit the content of what it is they're trying to get across. And I have to tell you, especially after teaching legal writing for 17 years, it is so interesting to see the different topics that they choose and the way they express themselves. We talk about, I know they get excellent professional identity development in externships, and I do think they also get some professional identity development in designing their blog as well. Who do you want to be? What voice do you want? We're like, in real blogging, real lawyers, some of them do use profanity. We're not really going to use profanity in our class, but it actually is a thing among a certain subgroup of bloggers. So that has been really neat, and like I said, this is the 4th year of doing it, and we'll continue it. We've gotten good feedback in terms of the students. Like, one person got a really great job in compliance, and she's like, I use my blog posts as my writing sample for compliance work, and they loved it, that it wasn't a memo. So that was really an expected benefit as well. And we also recently heard from a student who's at a criminal defense firm that's like very entrepreneurial for each lawyer in terms of, I guess what they earn and who their clients are and that kind of thing. And he said, I've become the WordPress guru at my firm because we're all supposed to be doing this kind of marketing to reach out to people, and so he knows how to do it as a result of taking the class. He did his capstone blog on, like, he was working out all the time, and so he did like FDA supplements, like the law of FDA supplements, and he wrote a post on people who they wanted this. There's a supplement that is for humans, but it's also for like pets and animals, and so the guy like went and got the supplement from the pet store and was taking it. So that's the kind of cool thing that it's just really interesting. And that leads me to my slide comparing traditional legal writing and public legal writing. So traditional legal writing, which I teach and love and think is foundational and wonderful, as we know, is privileged until it's filed. So it is expressly intended to be just between you and your team and the client. It is never supposed to go beyond that until it serves the client's needs. The ideas are dictated by the case. You don't get to decide if you want to, explore the jurisdictional issue unless there is a jurisdictional issue that comes up in the case and someone has given you that assignment. I feel like, and this might resonate with you, a lot of what we talk about in traditional 1L legal writing is managing the scope of your assignment and letting your supervisor use you as a resource. Like, please do just what I asked you to do. And if you see another issue, add value by recognizing it and bringing it back to your supervisor so that they can then tell you whether to go ahead and do that or whether they already know the answer or what. But you've got to manage the scope of what you're doing, dictated by the case and by the resources of the client. The writing really must be read. It has to be read by someone. Like your memo, your memo is written to be read to solve a problem. Your brief is written to be read by the court to solve a problem. They may skim it, but we're all under at least the fiction that it's all going to be read to solve these problems. And so you sort of have a command audience there. And the audience is, as we know, judges and lawyers, your client to an extent, but especially for 1Ls, it's like you're writing a memo to a senior lawyer, and then you're writing a brief, a motion for summary judgment or an appellate brief to the court. Some legal writing programs have writing a client letter, which I think is fantastic and great and is a good amendment. In our program, we have this email competency, but the different professors have autonomy in how we carry out that email competency. So for example, my students send me a report on where they are with their appellate brief, attaching their outline and giving an update on their research so that I'm like making sure they're heading in the right direction. That's very much a supervisor email. Some of my colleagues have their students write an email to their client after they do their oral argument explaining like how did it go and what can you expect and that kind of thing. So there is some direct client writing in legal writing programs generally, but not necessarily every single one of them. I agree with the comment. Email has become much more a part of the traditional legal writing, 1L legal writing, and that's for the good. I mean, you started complaining and saying they're doing a bad job at their emails, and I thought about that a lot. And I'm going to tell you, my students this year are awesome at email, and I think it's not even. I don't think it's what I taught them. They were good from the beginning, and they've just gotten better. So I'm very hopeful about.
So am I.
Yeah, exactly about that. So. Traditional legal writing, of course, is like explain the law, apply the law, IRAC, like the paradigm, the syllogism, that whole thing. I mean, it's a box, get in the box, like do this. You've got to explain it and then you've got to apply it. I'm not saying that's the end of it, but if you can't move on until you can do those basic things. The format, as you know, is on paper or PDF. There's judges on iPads and all that kind of thing, but it's basically a paper-based model or a simulation of paper. And then, here's that question of voice and creativity. Like my mentor was taught by his mentor, and then he taught me, Ken, if it looks like you had fun writing it, you should probably take it out. If it looks like you had fun writing it, you should probably take it out. His point was, you're not writing for yourself to be Shakespeare or to like express yourself and like realize your personal identity or whatever. You're writing to help your client. So maybe creativity helps your client, but it needs to be for them, not for you. And then there's more of a role now for images and charts. So like Ruth Ann Robbins and Steve Johansson have a really great article on how to bring in diagrams into memos and briefs called articulating, get it? Like art-iculating the analysis. And that's a really cool article for, like I said, legal analysis and pictures, but it's still like kind of limited. I mean, it's not like you see a picture in every memo or every brief, you don't. That's traditional legal writing. And then public legal writing, I have a paper on this, and just going to kind of, it's the opposite of everything I just said, really, you know. The point is to share it. You can get your idea from anywhere. That's the cool thing. Like, if you want to write about, you know, guys who lift weights taking a fish food for their supplement, you can. Like, nothing's stopping you. I had another one that I thought was so interesting. A student, he himself was an unvaccinated adult, and so he wrote a blog about the legal rights and legal situation of unvaccinated adults. So that's, you know, it's like something that means a lot to you. He interviewed his mom because that was clearly, you know, that his upbringing was part of his experience. So he was able to bring part of his own life into it and just have more of a voice and be creative in terms of where he got his ideas. So that's the good news. The bad news, I guess, is that nobody really has to read a blog. You know, like if a blog is created but never read, does it, you know, when you set up your WordPress blog and it's like there's statistics and it's like 0, 1, 2. You know, how many people are reading it? So it's optional, and that means also sometimes they may just read the first paragraph and kind of not really read the rest of it. The audience is, well, the audience, your intended audience might be lawyers, but the real or whoever, but everybody can read it. You can't erase it, you can't take it back. My blog on Listen Like a Lawyer, I have this one post on, I went and found like, there's college textbooks on listening, like there's college classes, which I didn't know when I got started, and there's a model, HURIER, hearing, understanding, like responding, interpreting, evaluating, responding, something like that. The HURIER model of listening. That post is by far my #1 viewed post because college students every year when they have to write their term paper on that model, Google, what is HURIER? And so I can see their searches and they're like, HURIER model, what is the HURIER, blah, blah, blah. I'm like, oh, it's test time again, all their papers are due. I really didn't intend for, you know, the students in college listening 101 to be one of my most like faithful audiences, but they are. So you can reach people, and to this point about, you know, who's seeing it, you can reach people who are hostile, very hostile to what you're saying, you know, like, or you could reach people who don't, like, so one of the students had a blog on, his capstone blog was about the religious rights of prisoners. We have a really strong law and religion program, writing about the religious rights of incarcerated persons. And I'm like, I guarantee you're going to get emails from people who want your help to like exercise their religious rights in prison. So you know, we have the General Counsel of the State Bar of Georgia come in and talk to them, and we talk about disclaimers and contact forms, and we code the contact forms so that they check and say, like, I realize you are not my attorney, or I am not forming an attorney-client relationship, so they opt to acknowledge that in that way. But, you know, they will, you know, reach people who are seeking their legal advice, even though it says, I'm a law student, this is not legal advice, etc. In that regard, I think it is a little bit of an experiential class because you're, like, if they post their blog publicly, people will write them, no matter how many words they use to say I'm not a lawyer yet. So what is the, like, analytical model, or what is the content model of legal blogging? You know, so if memos are explain the law and apply the law, like have an element test, etc. The thing about blogging is it can be like anything, right? Like it's so much more flexible. You can inform people, you can analyze current issues. Like we talked about, you can just like, one of the best ways to get people to read your blog is to just think of the questions that your target audience would have, like, can I get a divorce? How long does it take to get a divorce? What are my legal rights when I get a divorce? How do we split the assets? If you just sit down and think, who am I serving and what questions would they have, and literally write your blog around those questions with those questions as headings, you will get people to read it. And so the models for how to do this are so much more creative. One question is, how do you add value, or like what's really worth writing about? So one guy that I know, he started a blog maybe 10 years ago, and he did it by, he summarized every contracts case in his state, and he just wrote a new post on each case. Now, that is extremely boring and is a really long project, and I don't think people read those case summaries anymore. It helped him to get the confidence to do more analytical things, and he left them up there, but that's how he did it 10 years ago. I don't think that's necessarily how you would want to start now. There is, my slides, I think I lost my resources page, but I want to point out this good article by Jack Goldsmith on the Lawfare blog. If you've heard of Lawfare, that's a pretty prominent blog about current things going on with domestic security, terrorism, that kind of stuff. Lawfare, F-A-R-E. So his article is like, I think it's successful online legal writing for law students. Successful online legal writing for law students. The guy's name is Jack Goldsmith. Is he in Chicago maybe, I think? I don't know where he is now. It's basically asking this question, how can a law student make a contribution in online writing? Like not a law review article, but just like a blog post or a piece of analytical online writing. So he has a lot of different questions for how students might brainstorm topics and be analytical. The delivery is way more visual. Basically, I think you would want some kind of a photo or some kind of a chart or some kind of an image that makes it more shareable. It's just the best practice, really, for online writing. The ethics piece of it comes in a lot because people are like, oh, I'm gonna put up a picture. I'm writing about, Kanye West. I'm going to put up a picture of Kanye West. Or I'm writing about Beyonce. I'm going to put up a picture of her, Beyonce and Ivy Blue, her baby. And I'm like, that's a right of publicity, and that's a copyrighted picture from Getty Images. You will get a takedown, literally. You will get a cease and desist letter. That is not a best practice in this class. So that we really talk a lot about the ethics of using images in Creative Commons and other zero copyright sources like Unsplash, which has wonderful, beautiful pictures, usually no people, because once you start getting into images of faces, you're getting into personal rights. So a lot of the Creative Commons zero images are nature-oriented, which may or may not fit with what you're trying to write about. But the ethics of using images, I think, is another good real-world aspect of this kind of writing. So I joke with the students and I say, like, in this blog class, you should just do everything I taught you not to do in 1L legal writing. And that is true with respect to like blue booking. So unless you're really writing to a bunch of legal nerds, we would say don't blue book, just link to public sources. And certainly don't link to Lexis or Westlaw or Bloomberg, because those require a password. You need to link to a publicly available source. So it's another way to enrich their legal research training by sort of tipping their heads more towards the publicly accessible legal research. But even though there's a lot of differences, I still think there are actual commonalities and foundations. So to the extent you're like trying to reinforce with your extern students, like what do you know that you can use in your public legal writing and your externships? I mean, accuracy. Hello, you got to be right. Like you are a professional and you're putting information out there for lawyers or non-lawyers. You don't just guess, you don't just speculate, you need to have accurate information. Headings. So they would have learned a pretty traditional style of headings in 1L legal writing, element by element or argument by argument. And blogs may have, they do have a more flexible heading and more frequent headings. Have you ever seen that F-shaped attention span of how people read? This is from, I think, the Neiman. I think that's right. But they watched people's eyes to see where do they go on like a website, and basically their eyes go like this, and then they kind of go like this, and then they kind of go like this, and they don't really read anything like over here in the right-hand corner. But every time you have a heading, they wake up a little bit more. So it's called the F-shaped reading pattern. So you do want more. Strong paragraphing skills, so they really should, in one-on legal writing, they should be hammered with like write good paragraphs. Like please write topical paragraphs with strong topic sentences, and that can still help them in blogging. They need shorter paragraphs, really. They can have fun, with one sentence paragraphs. In my traditional 1L class, I'd be like, if you have a one sentence paragraph, it's like very choppy and underdeveloped, and you're not saying anything. But a one sentence paragraph in blogging can be great. Still, you can build off of that a little bit in terms of having good public legal writing. Be clear, be consistent, that's the worst, is right, like whatever you do, it's a difficult world, there's difficult questions to answer. Just pick something and be internally consistent in your document. You may not be able to figure out how to define a term, but don't pick 7 ways so that you can just have all 7 and basically be right 1 out of 7 times. Just pick one and go with it. So clear, consistent, and concise. The other thing is, I think that hopefully the narrative structure that they get will help them in terms of storytelling and being their statement of facts training. Narrative is just as valuable and maybe even more fun in blogging. So I think they may be constrained. They may feel constrained a little bit, and you can just give them permission, tell a story. Just go ahead and tell a story. So I'm going to speed through this. There's a bunch of different styles, because this is our time, right? Is it 5:45? So here's what I'm going to tell you. This is my closing point. You could have a class session. This is my big payoff right here. You could have a class session to help your externship students get ready for the type of public legal writing they may do in their externships. And it's built around the idea of this is a different genre of legal writing. A memo is a formal genre. A brief is a formal genre. That means a type of document with predictable conventions. I teach out of Alexa Chu and Katie Priel's book, The Complete Legal Writer, which really tries to get this idea across. Look, you're not just learning to write a memo or a brief. You're learning to do legal writing, which means studying a type of document. Get 3 or 4 samples, figure out what they have in common, and then try to do that for your next project. I think that would be a very valuable lesson to reinforce for your externs, because you don't, if they've never seen a cease and desist letter, they may be like, I can't do that. They should be able to get some samples, figure it out, and do a decent draft by using genre study methods to then generate a version of a cease and desist letter. So same thing with public legal writing. I have some samples up here which you can take with you when you go get your glass of wine very shortly here. And the idea would be, look, here's some samples of blogging or whatever. Here's some samples of stuff that representative externship contacts have put on their websites. You might be asked to do this. We want you to be ready when you're asked to do this. So let's go do a group exercise where you look at these samples in small groups and discuss them. And basically, to do a good genre study, you want to ask them to analyze the purpose. What do you think is the purpose of this document? Why is it here? What need does it serve? What need does it serve of the person who wrote it? What need does it serve of the audience? And then, of course, that leads to who is the audience? Who is this for? Is this for lawyers, judges? Is it for potential donors to the group? Are you fundraising? Is it to opposing counsel to scare them? What is it? Who do you want to read this? And lastly, what is the persona of this? Who are they trying to be? Are they trying to be friendly, your helpful lawyer? Are they trying to be your technical expert? Are they trying to sort of bridge two worlds? What persona are they getting across there, and what words and choices are they using to build that persona in their document? That's a really fun, I think, I'm a legal writing person, so I love this kind of stuff, but it could be a really fun way to sort of get them talking about what they think they know about legal writing, and you could help them realize that they know more than just writing a memo or a brief. They have some really good skills and they can transfer them if you just kind of push them along a little bit to see how those skills will bridge into this additional kind of writing. So thank you so much for your time.
Thank you.